friends, good afternoon. Come and sit down with me and don't leave too soon. Thank you for stopping in, thanks for saying hi. Together we can make a difference if we try. Thanks for saying hi. Together we can make a difference if we try. Hello there, my lovely friends. Good afternoon. Come and sit down with me and don't leave too soon. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try.
Well, good afternoon, everyone. Welcome in. Welcome into an interesting Lori Daybell day. Try to say that 5 times.
I was about to say, Joe, don't. I can't say that right now. I'm making coffee right now, trying to stay awake. You got me trying to say stuff.
And we're going up directly against Bob Motta. So that's awesome.
Oh, Lord. Is he covering Lori?
No, he's doing his Ladybird thing.
Oh.
Or not Ladybird, his Songbird Lane podcast.
Oh.
Yeah.
Well, don't look at it as going up against. You're just having different topics, that's all.
Right, yeah. And different perspectives. Songbird, yes, Songbird Pokemon. That's okay. That's all right.
Hey, Pokemon. I'm sorry, I didn't see her today, so I'm like, hey, Pokemon, I missed you.
Yeah, different topics, different perspectives. I mean, he's been covering that for a while, so you want to go drop in on that if you're following that case, that's fine. You don't hurt my feelings at all. But I was in court today, and I think Lori got her feelings hurt just a little bit.
Aw.
Judge Beresky, he told her she should have been preparing for court a little bit better. And her investigator and this 22 terabyte hard drive were an issue. There were lots of issues. We'll get to that in a minute. First, before we get to that, I want to Sujoy, welcome in. Hey, good to see you.
You're welcome in, Sujoy. Always nice to have you in here.
Absolutely. So how's the weather down there in the Panhandle?
Great. I'm so happy. It was, I woke up to and I don't ever look at the weather, but it popped up. So I was like, okay, I'll bite. Got it 70 and beautiful and sunny. I was like, yes. I've already been outside and had my outside time. My kid, my 18-year-old, come out to visit today and brought his new girlfriend to meet me. And so that was a good time. I got to do that as well. And then she's really sweet girl. I like her a lot. She's really pretty. And anyway, they left, and then I went outside and had some time out in the yard for a little bit. And now I'm in here at the desk again.
Yep, here we are again at the desk again.
Sweet Melissa says, hi from sunny Pennsylvania. Nice.
Oh, hi, sweet Melissa.
So I want to start singing it now, girl. Sweet Melissa. I'm going to start singing. Love some good music.
Yeah, the weather was, we had a cold front move into the valley, and it only got up to 68 today.
Oh, well, you're just like 2 degrees below me.
Right.
Hey, Trace on the case.
Trace, hey, welcome in. This is my partner in crime for this
Partner in
crazy trial.
crime.
Yep.
The
Trace,
duo.
no, I did not take a nap. I
Yeah,
was up
don't.
all.
Trace is gonna call you out. We both know you a nap taker, so am I. Sometimes
Well,
we nap, forget to wake up, don't we? And we're like, oops.
yes, we do. Yes, we do. So, I when I was on live with Miss Shorty last Friday night.
You didn't fall asleep on her, did you?
Not on her, no.
Okay.
But I
Okay.
did take a nap, and it lasted a little longer than I wanted it to.
Oh yeah. Because I talked to you after that. That's right.
I had all kinds of alarms set, so there was no chance of me sleeping in unless I slept through all like 4 of my alarms that I had set. But it
How
was
do you,
like,
you know what? My brother-in-law and my sister, right? Like, I mean, talking years ago, 30, 40 years ago, I'd be at their house. There'd be like 5 alarms going off and they're not waking up. And I'm like, how in the world can you sleep through all of those alarms? How do y'all do that? Are they just not loud enough? They all going off at the same time? You got them in different times? What's going on here?
well, I think that after my bout with COVID in December, I think I may now have sleep apnea,
Oh, yeah.
and
Well, you
that
need
will
to go
make
to
you.
the doctor, Mr. Stubborn.
Do I have to?
Guys, Pokemon Trace, help me out here. He won't go to the doctor. We need you boots on the ground and healthy, dude. Get to the damn doctor. That'll get you going.
Right? Yeah. Then boots on the
CPAP
ground
time,
today.
Pokemon, right? CPAP time.
Yeah, I think it might be. But anyway, I woke up like 17 minutes before that live with Miss Shorty, and
Oh,
I
no.
sat bolt upright in bed and looked at my phone, and it said 4:43. And for just one half of a second, my brain thought it was 4:43 a.m. and not 4:43 p.m. I'm
Dude,
like,
I, I hate when I do that. I do it all the time. It's
well, I've got
weird because it messes with you, right? For a minute, you're
it
like, what's
does,
happening?
yeah. And I was
That
like,
happened to
okay,
me the other day.
I've
Yeah.
got 12 hours before the live, and then I asked, I got to say it quietly or she'll respond. I asked Alexa what time it was. And she goes, 4:43 p.m. And I'm like, oh, shit.
Joe, you got that spying lady in your house. Get her out of there.
I have
Good
them all over. I
Lord.
have them in every room. In the bathroom, in the kitchen, in the
You got her in the
bedroom.
bathroom?
Yeah. She's got
Why
to
do
play
you
me
got
some
her in the
music from time
bathroom?
to time.
Does she flush the toilet for you?
That would be awesome. But no, she plays music for me while I'm putting on my makeup and doing my hair.
Oh, good Lord. Okay. All righty. All right. Okay, Joe. Mm. Mm. I
Oh,
don't have
good
no
grief.
Alexas anywhere near me. My Android listens to me enough. Last thing I need is Alexis doing it too.
All right, Rondi's trying to catch up on this case. So
All right.
let's start getting into this case because there were a couple of court documents that were dropped on Sunday that I haven't had to look over until this afternoon when I got back.
I knew there were some new ones dropped that we hadn't reviewed yet.
Yep, there are. So
Joe, Melissa says that her brother's on a CPAP and he feels much better.
Yeah, I have been told that you get so much better sleep, and if you're not sleeping well, your whole life can be just
Dude,
like
you're
upside
talking
down.
to a lifelong insomnia sufferer. I know it will tear you up. Ugh.
So, Rondi, thank you for subbing. I appreciate that.
Nice.
Very much.
Mm-hmm.
Slowly creeping up there in numbers. We're going to get to 1,000 someday. Maybe during Lori's trial, I can get there. But I appreciate each and every person that has subbed now.
Yes, sir.
All right. So here we are, March 16th, 2025. So that's Sunday at 11:57 p.m. That is just such an odd date and time to file something with the court. But that just means the prosecutor's working weekends, right? Like,
Well, I guess so.
prosecutors probably don't get many more days off than a lot of other people, but especially when they're working on a big case like this. So
Yeah, but the court They usually, it goes to the court, clerk of courts and gets uploaded. So it's weird that it was on a Sunday. That it is
Yeah.
weird.
Well, they have e-filing now, so maybe it is like
True
automatically
that.
e-stamped up there now.
Yeah, true that. Hey V, welcome
So,
in.
V, hey, no worries. Good to see you in here. We're going to try and get
Aw.
caught up.
Melissa said she loves it here, Joe.
Oh, we love having you here. You keep distracting me with chat, but
Well, you know me, I can't, I love to communicate with the community. I just,
yes, I know
let
you
me,
do, and that's
let me
something that
turn
I
off
need to get
chat.
better.
All right, I got chat out of my way so Joe can get on with his
No, no,
document, guys.
no. You need to be watching chat for me, so because I'm going to be watching docs and talking about the docs.
We love this bar. Y'all gonna get me singing on the damn YouTube.
So this is from the state. Separate statement in support of Rule 15.7 request for sanctions. So we're talking about
Ooh.
sanctions here. Sanctions are no bueno.
Is this Lori's filing, right? Or is this which one is this?
I think it's by the state. Trina K. Trina K. is defense attorney. No, deputy county. Trina is the prosecutor. So I believe this is a state filing. I believe
it should tell us right there at the top of the filing as it starts out. They'll say this is the state or this is the defense. Yeah.
Well, the state of Arizona, right there.
Okay, so
Through
they're wanting
undersigned
to hold.
counsel.
They're wanting to hold sanctions against the defense, which is Lori.
Well, she's acting as her own attorney. Can she actually be sanctioned as an attorney, though?
Yeah.
That's an interesting concept.
Yes, if you are your own attorney, then yeah. What do they say? Read the document. I'm curious now.
All
Read
right.
it.
Yeah, let's go.
Okay.
The state of Arizona hereby provides a separate statement pursuant to Rule 15.7a, identifying the state's personal attempts. Okay. This is about the witness list. Identifying the state's personal attempts to consult with opposing party to resolve two issues related to defendant supplemental 15.2. That was her witness list. State's request for defendant to either set up interviews with their noticed witnesses, that's Lori's noticed witnesses, or to provide the state with contact information so the state can schedule interviews with the witnesses. And that was discussed in the hearing today. So we'll talk about that later in more detail. Number two, the state's request for a report from defense expert Lonnie Dworkin, a summary of the subject matter and opinion of Mr. Dworkin, and or a timeline of when Lonnie Dworkin's work will be completed. So this was Sunday. We're only a day and a half after this was filed. The state has attached emails to defendant's paralegal. Defendant has a paralegal, Ana Lena Ramirez, emails to defendant's investigator, Jeff White, and an email to defendant's advisory counsel, Pamela Hicks and Robert Abernathy, asking for the address, contact information for the listed defense witnesses, asking if the defense will be setting up interviews with the defendant's noticed witnesses, and asking for any information about defense expert Lonnie Dworkin's subject matter, opinions, and or completion of his work. So spoiler alert, folks, Lonnie Dworkin has not done anything on this case at all. Now, we learned in a hearing today that she requested him to be approved back in January, and he was not approved for her because, you know, the state has to pay for him because she's indigent or whatever you call it in Arizona. The state has to pay for it. So they have to approve so many hours for him to work on her case. And it literally took them a month and 3/4 to approve Lonnie Dworkin to work 10 hours on her case. We learned that today. And he has not done one single minute of investigative work on her case yet. After sending multiple emails, the state has still not received any contact information for the 12 noticed witnesses. The state has not received any response regarding the defense setting up interviews for the state, and the state has not received any response regarding the subject matter, report, opinion, or completion date of defense expert Lonnie Dworkin. The state has attached the emails to support the requirements of Rule 15.7a. So we know that according to the rules of evidence in the state of Arizona, she is supposed to have all of that done and submitted through discovery to the state at least 30 days before trial. And we know we're going to jury selection on March 31st. So she has not complied with rules of evidence, and she actually has a really interesting comment that I wrote down verbatim after she made it in court about this rule, the rules of evidence, and how it applies to her, and her using a state-paid defense expert in Lonnie Dworkin. So here, I'm not going to read through all of these emails. We have attachment A. These are emails. Trina K, she's the prosecutor. She asked for stuff. And there's more. That's Anna. She is backup defense. Oh, no, she's the paralegal. Anna is the paralegal. I mean, there's emails and emails and emails and emails. I mean, there's like 20 pages of emails, because this whole document is like 23 pages long. So I don't want to go through all this and read all of this right now. I can post it online. In fact, I will post it online, but
put it on your YouTube community tab in case those aren't on Twitter. I mean, you can do it on both. But...
Yep, I will do it on both. I'll put it in my YouTube community chat. I'll put these documents on there. So y'all can read through the emails if you want, but I'm sure the state probably has a pretty decent case. I'm sure they probably do. But
we should all be really good at reading court documents by now, right?
Yeah. But
you
honestly,
can't discuss these cases without reading them. But a lot of that stuff, you're right, is, it takes forever to read some of it. But yeah, post it up so people can read it if they want.
Oh, here's one right here. We're on page 15. I just happened to randomly stop on this page. Has Lonnie done any work on the case? If an expert hasn't written a report, Rule 15.2 requires a summary of the subject matter and the expert's opinion be part of the disclosure. Also, is Joseph Pongratz being noticed as a witness? Finally, Rule 15.2 requires the name and address of each witness. So, Lori complained today in the hearing that she's on lockdown 23 hours a day and doesn't have access to the internet, doesn't have access to a cell phone, doesn't have access. She didn't mention tablet, but I assume she also doesn't have access to a tablet to be able to be doing her own work. So she complained about that, and I just wanted to ask her, how much access does Charles Vallow have to the internet? How much access do JJ and Tylee have to the internet? They're in the afterlife, whatever that looks like right now. So you want to complain about being on lockdown 23 hours? Go ahead. It's falling on deaf ears right here. Trina, we're still waiting on documentation, specifically Lonnie Dworkin's CV curriculum. That'd be curriculum vitae, kind of like a resume, and OPDS approval. Wait, what is the date of this? She sent this on March 12th, and she's saying they're waiting on Lonnie Dworkin's OPDS approval. But today in court, Lori said, we got OPDS approval on March 7th. So I'm not sure if there's miscommunication or if there's, I wouldn't think that a paralegal would be, engaging in deception. I don't think that's it. It's got to be miscommunication. Oh boy. This is just like 23 pages of back and forth and back and forth. We just saw that. Please advise if I need to file a motion or if Mrs. Daybell, she got it right this time, it's Mrs. Daybell, will be complying with Rule 15.2 C2. Thanks, Trina. Right, Trace. All right, I got to switch back to chat for just a second. Oh, chat's going. Love it. You see the attached defendant supplemental rule 15.2 notice of defenses and disclosure. We've already gone through that. Okay, so that's this document. I will post it on YouTube and I will post it on X. We don't need to go through all that now, but here is another interesting motion. It's a little shorter, but to me just as interesting. This is the state's motion to preclude defense expert Lonnie Dworkin and preclude noticed witnesses. The state of Arizona, the state of Arizona, through undersigned counsel, requests this court preclude defense expert Lonnie Dworkin, as the defendant has not complied with rules 15.2C2 and 15.6B, Arizona Rules of Criminal Procedure. The state further requests that this court preclude all, oh, holy cow. I scrolled too fast. The state further requests this court preclude all other noticed witnesses, as the defense has not complied with Rule 15.2C1, Arizona Rules on Criminal Procedure. On March 6, 2025, defendant filed a supplemental Rule 15.2 notice listing defenses and witnesses, and we went over those because they gave us insight into what she is planning on presenting as her defense and witnesses on her behalf for both this case and 2020 and the 2022 case, which is Brandon Boudreaux's conspiracy to unalive him. In defendant's supplemental 15.2 notice, she lists 11 potential witnesses, but does not include any address or contact information for any of the witnesses. We're up at the top now. Defendant's supplemental 15.2 also does not provide any written or recorded statements of the witnesses. So that means the state has to interview her witnesses. They have to be given the chance to depose them prior to the trial to find out if they have any information that is relevant to the trial and may be inculpatory or exculpatory in their favor or in her defense. Many of the named individuals were not contacted by the police, and therefore the state cannot readily obtain that information. On March 7th, 2025, so we're talking exactly 11 days ago, the state reached out to the defendant's paralegal, that's the Anna gal, and asked if the defendant could identify which witnesses and defenses were relevant to 2021 or 2022. On March 11th, 2025, the state emailed defendant's paralegal, Annalena Ramirez, and asked if the defendant would set up interviews with the 11 witnesses, or if they would prefer the state set them up, and then the state would need phone numbers for the witnesses. In a later email, the state asked if it would be better for the state to reach out to the witnesses or if the state could go through. So this was actually talked about in the trial again today. And her investigator, Jeff White, who is mentioned down here in the bottom of this paragraph, is actually a relevant dude in this trial. And part of that is due to the fact because she is incarcerated and in her access to being able to track down her witnesses is limited. I mean, that is a fair argument on her behalf, but apparently they have given her, and I assume that the state is paying for this investigator, Jeff White, who was in the trial today. And the judge actually allowed him to come into and sit at the defense table next to her, which is a little bit unusual to me, but I think it's the judge just like giving her the benefit of the doubt and saying, okay, I don't want you to claim that you not having the investigator by your side to ask questions and answer questions could limit your defense in any way.
Well, to be fair, we have to separate Lori Vallow, the perpetrator, from Lori Vallow, the defense attorney. And it's normal to have that stuff happen, to have your team there at the table. Look at Karen Reed's team at the table. Look at Brian Koberger's team at the table. So I'm not, giving Lori any justification here. I'm just saying from a legal standpoint, there was nothing wrong with that.
Well, there are very specific rules regarding what people are allowed to sit at what tables during a trial.
And I
And
understand that, but there's a lot. I mean, I'm saying they usually have their team right there with them. I don't know about Arizona, but if I'm going to give all other defendants the same lenient, the same things, I've got to give it to Lori. It may not work in her favor in the end, because I don't think she's not going to be found she's going to be found guilty, in my opinion. But I'm just saying, I think that right now, this is just me thinking, because this is my true crime brain coming in. She's a defense attorney and during some of this process, and not just the person being tried, right?
right. So in Karen Reed, we saw a tiny table guy off in the back. He had to go sit by himself because he was like just a technical advisory kind of guy that was doing their audio
Right.
visual presentations. He didn't get a seat at the table. And then
Well,
that
that's
one,
the audio visual guy. He wasn't an investigator.
well, but in that case, it was only attorneys in the defense that could sit at the defense table. In a lot of states, that's the rule. Obviously, in Arizona, it's flexible, which is fine. I don't have a problem with it. Trace on the case said that he had bedhead.
Yeah.
I told her it was in.
I didn't look at him that well. Did he really?
Yeah, he kind of had these feathers going back from the back of his head, but I think it was an intentional do. Like, we're gonna have
Oh
to check
God.
up. Yeah, I think it was intentional. I really do.
Oh goodness gracious.
Yeah, we're gonna have to watch some of
Hey,
that.
beach bum, listening and driving. I used to do that all the time. Be safe while you're doing that.
Nina
I
Canadian,
used to
welcome
stop at
into
red
Beach
lights and
Bum.
comment.
Oh
Pull
gosh.
over and I'd pull over and comment. Like, I know I got a comment. Let me pull over.
Simply Bell, welcome in. Hey, good to see you in chat. Always. So anyway, he was allowed to sit at the table today. That was like one of the very first things that they handled as a matter of housekeeping. Like, Lori was like, I need this guy by me. She needs a guy by her, apparently, for the rest of eternity. The state provided availability. So we're down here. Oh, okay. We just read up here, Jeff White. On March 12th, Annalena Ramirez, so that's paralegal, responded and advised that the state should go through investigator Jeff White because he's her boots on the ground. Like, y'all had me with boots on the ground there today. Jeff White is Lori's boots on the ground, like getting these investigations and interviews done. CC'd Mrs. Ramirez in case he needed assistance with scheduling on March 12th. The state emailed defense investigator Jeff White and asked if he was able to set up interviews, I'm guessing, with whichever witnesses Mrs. Daybell intended to call for the 2021 case. That's the one currently getting ready to go to jury selection on March 31st. The state provided availability to conduct those interviews on Friday, March 21st. That's this Friday. The state did not receive a response to this email. And that reminds me of something that I didn't mark down in my notes. So y'all are going to get a little insight to this. Jeff White is in the courtroom sitting to the left of Lori. And he goes, yeah, when I headed out of town, I must have forgot to hit send on that email. And I'm like,
So
dude, are
we
you
got a
serious?
Timu defense team, right?
I'm like, dude, are you serious? You have one job. And it just, like, that's an excuse I've heard from somebody who has been lying, and that's an excuse I've heard from somebody who's been telling the truth. So,
Well, you know
I'm
what?
not,
Since the state's paying for all her stuff, she's not getting top-notch people. You know what I'm saying?
yeah, and that's how he came across to me today. Like,
Yeah.
I think he was the guy that was in the front row at the last hearing on the 11th. I honestly do, because she looked at him, smiled, she said something, he said something. And actually, I noticed today, because I'm sitting in the front row, that they have signs up that say any communication with witnesses in custody will result in or strictly forbidden or something like that. I don't know what it was, but he sat in the front row and he had communications with her. And granted, if that really was her investigator, then I guess that's a little bit different, but it's still like there's court decorum, and you don't violate court decorum. And unless you're in Judge Cole's and you stand up in the back row and say, "We can't hear the witness."
Yeah. You heard it. See, dude, we've had defendants jump up and attack judges in the courtroom.
Yeah.
Some folks don't care
Yeah.
about decorum.
Right. Anyway, let's get through this. Holy cow, we're only on page 2. On March 12th, 2025, the defendant filed another supplemental notice of defenses and witnesses. In this supplemental notice, the defendant notices the same previous 11 witnesses. I thought I saw duplication of filings. I thought I did, because I was going through, I already have like 400 documents on this case, and I have trouble keeping track of them. But okay, she
It's
notices
like Idaho 4.
She notices the same 11. One of the witnesses, Lonnie Dworkin, was mentioned by the defendant at the status conference on March 11th, which Trace and I were at. Yeah, Trace, he was emailing stuff to the prosecution at 10:30 last night. Yeah, I'm just not impressed with this guy. I mean, he's got a nice bedhead, but other than
Well,
that,
look who he's working for. Look who his defense attorney is. He's working for.
yeah.
Lori
On March
Daybell.
On March 12th, the defendant provided the state with Mr. Dworkin's CV, curriculum vitae, which indicates he is a certified computer forensic examiner. The defendant did not provide a report by Mr. Dworkin or any summary of his opinion, because we found out today he hasn't done jack shit in this case. That has not done anything. And we're 2 weeks from jury selection. Less than 2 weeks.
Can you imagine, though, what is there for him to do, right? I mean, from an investigation standpoint, half the people that you need to speak to aren't even alive anymore, that were there to witness what happened that day. Tylee's not here. Alex is not here. Charles is not here. That leaves Lori. Who's he going to talk to, Lori? Or, or people out there who are going to support Lori? There's not that many out there.
Well, this is Lonnie Dworkin. He's the computer examiner, so he is tasked with extracting computer and cell phone records. And in particular, what was brought up today was Charles Vallow's cell phone. And in court, Lori called him my husband. She said that in court today.
Okay, is this guy they're talking about, though? He works for Lori, right?
Yes.
The defense. Right.
Yes, he's been granted 10 hours of examination time by the state to do some type of extractions. On
Charles's phone?
Yes.
And they're going to extract all those nasty messages Lori sent him? Okay.
As if they haven't been extracted already.
Exactly.
And that comes up too.
Each side's going to do their... That's weird. Go ahead. I'm sorry. Go ahead. I'm thinking out loud as you're talking. Go ahead.
Yeah, no, that's good. I like talking it out loud because it just make sense, right?
We try, but damn, sometimes it don't, does it?
Bright Wheel, welcome in. Hey there.
No. Good to see you again, Bright Wheel. She was with me this morning. I'm assuming you're she. Good Lord.
I want my husband's phone, not just the extraction of the phone. So that was a back and forth that happened in the hearing today. She said, I want my husband's phone, as Trey said, but I want the actual phone. And then the judge is like, well, can't Lonnie just go down to Chandler PD and do an extraction at the police department? And then the state jumps in and she says, I don't think Chandler PD wants anybody coming into the police department and doing extractions in the police department. So
well, then they need to figure that out, because if the prosecution that to me that's messy, because if they've been granted permission to do the extraction, then let them do the extraction. Don't stand up that's weird. And I'm not taking up for Lori. I don't want people to get all butt hurt that I'm taking up for Lori Vallow. I'm looking at this from the defense standpoint at this point, not Lori Vallow, the criminal. If they've been granted this 10 hours to do this work, how are they supposed to do it if they can't access the phone?
Right. And so that was resolved in the hearing today too.
Okay.
because
Yeah, because
she
like I
goes,
said, I got
how is that?
distracted in my chat and I didn't get to pay attention to a lot of what I was trying to
Right.
pay attention to.
Well, she goes, how is that logistically going to happen?
Right.
And the state said, okay, well, if they're willing to sign a form that once that phone is out of the police custody, that we're not responsible for any damage that happens to the phone or to the data on the phone. If they're willing to sign that, then her investigator can come and pick it up. So that was like one of
There's
the
you.
very last things they did.
Yeah, but I've seen court filings in other cases where evidence does leave like that, but they have to, there's protocol behind that kind of stuff. So
Right.
that's
And
weird to me.
yeah, and Lonnie Dworkin's CV might play a part in that. Like if he is a certified lab, then a police department should be able to transfer custody of evidence over to a certified lab or a certified technician of some kind.
Thank you, Bright Will, for clarifying. Now I know. Sorry. You just don't never know people's names, you know?
Right, I got it wrong last week, right? With
Yep.
Truth Exposed. Yeah, that was funny. Okay. Upon receiving the supplemental 15-2 notice with defense expert Lonnie Dworkin, the state emailed blah, blah, blah. The state requested the defense comply with Rule 15-2 and either provide a report or summary of Mr. Dworkin's opinion down here towards the bottom of the page. Scrolling up, advisory council forwarded this request to defense investigator Jeff White. Mr. White did not respond to this email request. He apparently has a problem responding to emails, and that's a problem. It's becoming a problem. On the 13th, they emailed him again and Anna and asked what Mr. Dworkin was being hired to do and the estimated date of completion. That became a huge issue in the hearing today. Estimated date of completion. So the state also requested the address and contact information for all notice defense witnesses. Neither Anna nor Jeff responded to the email request because they don't know. They don't know where all those 11 people are for sure, what their official phone numbers and addresses are. They don't know. She just like made up a list and she sent it out and she said, I want to talk to that Nate Eaton guy. And I just
I
imagine
don't know where he's at, but I want to talk to him.
I know where he's at. I can tell you where he's at. And he owes me a t-shirt. He told me last week that he was going to bring me a t-shirt. And if he's
Well,
just planning on, if he also told people, apparently Trace told me that he told people to stay home from the trial and just watch on TV. So that would help with the gallery, but we're moving to a bigger courtroom, so maybe more people will come. But if he decides to show up, he better have a t-shirt for me. Just saying. Nate, if you're out there listening,
Nate told y'all all to stay home. He's like, y'all stay home. I got this.
Right.
I'm teasing. I love Nate.
Yeah. Yeah. East Idaho News is probably going to fight that subpoena if he ever gets one on his behalf. I just imagine.
Well, I mean, I don't even know if I'd fight it. Like, what can you get out of Nate Eaton? I'd get in there and testify all day long if I was him. Like, yeah, I chased that bitch down to Hawaii. I sure did. Here's what she said. Here's the proof of what she said to me. Good luck with that, Lori.
On March 14th, the state again emailed Jeff White and paralegal Anna Ramirez requesting contact information and what Lonnie Dworkin was hired to do. So multiple emails. Furthermore, I'm just like skipping through some of this stuff. Furthermore, defendant does not comply with rule which requires the defendant to provide any report by the expert and the results of the completed physical examination, scientific examination, or comparison conducted by the expert. He hasn't done any of that. He's not done anything to date. He doesn't even have the evidence in his possession to conduct any examinations as of March 18th, 2025. March 12th, the state emailed the defendant's paralegal. We're talking about all these emails. So the state is actively pursuing the defense investigator, Jeff White, and paralegal Anna Ramirez with multiple unresponsive by especially Mr. White, but it's just like email after email after email after email that they're sending out and not getting replies to.
Trace says that she's high on subpoena power. Right, Pokemon, we don't know what her point is with Nate, right? What could he possibly offer the defense, right?
I wonder if he actually has been served with a subpoena by now.
I don't know.
Because her investigator, Jeff White, is doing the legwork for her. So probably is pretty easy to find out Nate Eden's mailing address and serve a subpoena on him. I mean, that's probably pretty easy. Like a week ago, I shook his hand in court. So why could Jeff White not walk over to him and say, here's your subpoena, dude?
Hope y'all can hear my typing in the background. I'm sorry, I'm responding to messages.
That's all right. You're all good. So the state, the top of this page. Here we go. It's getting spicy. I'm going to go back to the bottom of the first page. Rule 15.7a requires any party moving for sanctions for disclosure violations must include a separate statement that the moving party, that's the state, has personally consulted with opposing counsel and has made good. We know who opposing counsel is in this case.
Mm-hmm.
And has made good faith efforts to resolve the matter. The state has filed a separate statement in support of Rule 15.7 request for sanctions. Pursuant to Rule 15.7c1, the state is requesting sanctions in the form of precluding all of the defendant's noticed witnesses and defendant's noticed expert. The defendant has represented herself since December 6th, 2024. True story. I was there for that. When defendant asked to represent herself, she advised that she has been studying the criminal rules of procedure for Idaho and Arizona for the last 5 years and was very prepared for trial. Oh my gosh. I'm liking this filing. Basically, the defendant advised that she's the smartest person in the room and she's better at defending herself than an actual criminal defense attorney. During the you're going to make me try and pronounce that word.
You sound like me now. Stop it.
During the colloquy, I'm going to have to Google that word. Y'all just hang tight for just 2 minutes.
What word? I'm going to zoom in. Let me see on my phone. Colloquy. The colloquy.
Colloquy.
Let's find out what it means.
Colloquy. Basically, I think it's an extended rant by the defendant. During the colloquy, to ensure the defendant was prepared to represent herself, the defendant was required to sign a waiver form and was advised by the judge that she would be held to the same standard as an attorney.
Joe, it's a conversation.
Oh, okay.
A conversation. They broke off their colloquy at once, a gathering for discussion of theological questions.
Oh, so it was a discussion between her and the judge because Judge Beresky asked her, "What are your qualifications to represent yourself?"
Yes.
And then she went through and described how she's been studying law while she's been in jail for the last 5 years.
Yep, it's a conversation and a dialogue. Okay, fancy word for conversation.
I learned something new today. We all learned something
we did.
new today.
We learned some new words, y'all.
Soliloquy. Reminds me, Nina says it rhymes with soliloquy.
I just saw that.
I know soliloquy. I know that. To ensure the defendant was prepared to represent herself, the defendant was required to sign a waiver form and was advised by the judge that she would be held to the same standard as an attorney regarding knowledge of courtroom procedure, rules of evidence, and rules of procedure. The defendant agreed to this. Once again, it came into play in the hearing today. Beach Bum, yay, you can come in and chat now. You can tell us how to pronounce colloquy. And I just got it wrong again. No, colloquy, that's it, yeah. Colloquy, 3 syllables. Soliloquy is 4. Per defendant's paralegal, defendant requested funding for expert Lonnie Dworkin on January 15, 2025. So this was an important matter also that was brought up today. She requested funding and received approval for funding on March 10th. She said March 7th today. Not a huge difference because, I mean, it is 3 days difference, but it's not like 30 days difference. Defendant was in court on March 11th, 2025, and announced that she was ready. Announced that she was ready to begin trial. This is a really good argument on March 31st. So after having gotten funding for her technical expert for extractions from either computer and or cell phones from Lonnie Dworkin on March 10th, the very next day was the hearing that was held a week ago, and she announced that she was ready to begin trial on March 31st. This is a really good argument, well written. Defendant could have requested a continuance on March 11th to allow time for her expert to complete whatever testing review. Instead of complying with the rules, the defendant filed another supplemental on March 12th and noticed expert Lonnie Dworkin without including any of the requirements of 15.2c. This is exhausting. Starting on March 11th, the state has repeatedly requested the defense either set up interviews with their listed witnesses or provide contact information so the state can interview these witnesses. The state has also repeatedly requested information regarding Mr. Dworkin's work. The defense has not responded to any of these requests. At this time, the state has made good faith efforts to obtain contact information for the notice defense witnesses. The state has made good faith efforts to have the defense set up interviews with the notice defense witnesses and made good faith efforts to obtain information as to the subject matter of defense expert Lonnie Dworkin, as well as obtain any information as to when the expert's opinion will be available to the state. Trial in this matter is set to begin in 15 days. That was as of Sunday afternoon when they filed this. The state will not have time to interview the 11 defense witnesses and file any appropriate motions in limine, nor will the state have time to interview the defense expert and determine if the state needs an expert to rebut whatever Mr. Dworkin will opine. For these reasons, the state requests the court preclude all 12 of the defendant's noticed witnesses. So that's 11 plus Nate Eden. 11 plus the expert Lonnie Dworkin, pursuant to Rule 15.7c for violations of Rule 15.2c. Submitted March 16th, Maricopa County Attorney by Trina Kay, Deputy County Attorney. Wow. So that was a really well-written argument, and it was discussed at length in court today. So we can start going through my notes and like interject things that we just learned from that filing, because I hadn't been through that filing in detail yet. So we can interject things as we go. Man, she's the smartest person in the room. Good choice, Lori. Good choice to represent yourself. All right. Now I got to pull up my notes. Where are my notes? They are in JPEG format. Tell me I didn't close out of that. For real? I guess we'll have to do it one at a time then. All right. Page 1. So page 1 is the best looking of my notes by far. When we get to page 2, it's a little worse. And when we get to page 3, it's a little worse. Page 1, page 2. Only 3 pages today. It was a short hearing. They started at 8:20, and it was a short hearing.
So let me ask you this. So some people that were watching earlier with me, when the court went to recess, it never came back. You said that's actually when he ended it, right?
Correct. Yes.
Okay.
Yeah. When Judge Beresky says we're in recess, he means
We're done.
We're done.
Court
for the day.
adjourned.
Yes.
He doesn't say court adjourned. He just says recess.
Yes.
Okay. That makes sense because we were wondering.
And it's like elementary school recess where we all go running out to the playground and jump on the monkey bars. They don't have monkey bars at the Maricopa Superior Court for some reason.
That's too bad. Lori liked to dance on poles and send videos to Chad, so maybe she would like
Oh my
them.
gosh. I forgot about that. Holy cow.
She'd be out there all over them monkey bars. Look at me, Joe, and my pretty hair.
So Trace on the case and I got down there a little bit before 8 o'clock, and we got up to the courtroom. It's on the 11th floor. It's 1104. That's Judge Beresky's courtroom, which is way too small, by the way, to hold this trial. Way too small. So Lauren and I had a little counting controversy going on after the last hearing. Lauren from Hidden to Crime. She thought there were like 36 seats in there. Yeah.
Did y'all ever clarify? Did y'all clarify today how many were in there?
I did. I counted them one by one, and I was dead nuts on at 30. There were 30 seats in that gallery.
Dead nuts on. Good Lord. 30 exactly.
30 exactly. Now, there is one that's kind of in the back that's kind of double wide.
Pokemon. Oh, my God. Maybe she just needs a pole to perform her closing statement.
Oh, the guys in the jury probably wouldn't object to that, but I don't know.
I don't know. They might be like, "That get that freak away before she starts opening portals, casting spells, labels me dark." I'm waiting on her to label you dark. I thought about that earlier. I was like, I even chatted that in my comments. Like, I wonder if she's labeled Joe as dark yet.
Yeah, she won't make eye contact with me, so maybe she thinks I am a zombie. As long as I'm not
she's
Ned.
scared of you. Yeah,
like I want a better name than Ned. I don't want to be Ned.
Right? It's like, Lori, give me a better name than that. Because we know this stuff's not really funny, but it,
I gotta make fun of Lori,
Joe.
though. We got to make fun of Lori, though. We have to.
Yeah, she deserves it.
Yeah, and what's interesting today about the Ned comment, and actually disturbing, was when she said, "I want my husband's phone." Girl, you weren't calling him your husband near the end of his life.
Right.
And
actually, he's technically not your husband no more. You married to something. Remember in the Dateline interview, Chad, you mean my husband? Lori, get your husband straight, honey.
She likes to say that. She likes to say husband. Like,
I had to admit, she had many husbands. They're all gone except for Chad. Well, Chad's gone, but not at the hands of Lori yet. When they get exonerated because Jesus told her so, Chad better watch out.
Well, I'm starting to wonder if there is some personality deficiency in her that causes her to have a husband to feel more of her own self-worth. And I know that.
Oh God, yes. You know how many women out there, I don't mean to shame women because I have a sister I love dearly, but some people, some women, some men have to have a partner in their life at all times, regardless. I'm not that girl. I'm like, get the freak away from me. But there are people out there who have to have a partner at all cost. Unfortunately, look at Jen Soto.
At all
Some
costs.
people, I mean, for real though, it's true. If you look at society, and I had this discussion with my cousin one time because me and her sister, my other cousin, are both single by choice. And we have been for a long time. And we were having a conversation one day and she made a comment and I said, hold on. I said, do you think we are single because we're like bitches and nobody can tolerate us? And she kind of shook her head. I was like, no, honey, we're just not willing to put up with the same stuff you're willing to put up with. Right? I'm just not. But some people have to have that a person in their life no matter what. And I'm just not that person. Thank God.
Yeah, and
Yeah.
the Mormon Church contributes to that as well because it's such a patriarchal
Right.
society. And
Well, a lot of religions are like that. Once you're married, you're supposed to stay married for eternity, regardless of what happens in the marriage. You just do. But
right,
that's
it's not
not
just that
that's
though.
not correct.
It's the men in the Mormon Church. The men have the power and they have the say
Exactly.
so. But
Well, a lot of
she got
religions, if you fairly look at religions, a lot of them are like that. The man is the head of the household. Therefore, that's how it works. And I get they take it to the next level in Mormonism. I get that. But a lot of religions, and I've studied a lot of different religions, I've been involved in different religions throughout my life, but that's how they operate. He's the man of the house, right? And that's just the way it is. You're
well,
beneath him.
and then when she and Chad got into this fringe cult, doomsday cult, she was bestowed the priesthood upon her in the temple by Jason Mao. So that
Mhm.
like almost flips that whole patriarchal thing on her head because it allows her to be quote unquote sealed to Chad for time and all eternity, but it also gives her power that most Mormon women don't have. Like I know none in my personal life that have had a priesthood bestowed upon them by some guy who claims to be Captain Moroni in the flesh.
Okay, but did the actual church do that or did Chad do that?
No, that wasn't Chad. That was Jason Mao.
Okay, but he's not,
He's a part of that fringe cult with Chad and all of them.
exactly. Yeah,
Yes. Yeah.
exactly. So this wasn't
Yeah.
a normal, Mormon thing. It was just the fringe bullshit. And I think Lori was probably, and I don't mean to take this is because I've watched both trials and studied the case so long. Chad's a horrible man, but Lori also was just as horrible. And I don't know who did the leading there.
It's funny you mention that because my brother and sister-in-law who are practicing LDS, and I love my sister-in-law and I love my brother, obviously. They disagree like very vehemently on who was the leader in that. Was it Chad or was it Lori? And obviously she says it was Chad and he says it was Lori. So they're never going to come to an agreement.
Well, they fueled each other's fires, you know what I mean?
Yeah.
But
Yeah.
I think Lori had a lot of pull in that relationship as well.
Absolutely, she did. She was the
Bat her
charmer. Like,
eyes and sling her hair
yes,
around, and old Chad was just like, "Oh my God, she wants me. I'm gonna do whatever she asks."
and flash that toothy smile
Yeah,
like she did the day that Charles Vallow was killed, and she left for an hour to an hour and a half with JJ and Tyler and came back, and she's just casually out there in front of the car with that. Oh, it's so disgusting.
no, I don't think she's got Chud on her witness list, but I don't know about the state's witness list. I don't know.
That's a good question. I think they have enough digital evidence on him. So we're going to talk about that here in a second. There is a 22 terabyte hard drive of discovery that was turned over to the defense by the state. 22 terabytes. So they have actually done. Chandler PD has already done an extraction of his phone, and that is included in the 22 terabytes. She shouldn't have to go get his phone from Gilbert PD. It's not Chandler's, Gilbert PD.
Right, and 22 terabytes is nothing compared to what we've heard in Adelphi and Idaho. I mean, that's nothing.
Exactly. The
I'm
judge.
I'm tired of hearing defense attorneys across the board scream about all these terabytes we got, but at the same time, they're screaming, "You're not turning over all the evidence." Well, excuse me, you just said you got 100 terabytes of bullshit to go through. How can you say you're not receiving discovery?
And that's what the judge mentioned today. So
Mm-hmm.
that was another point of frustration with me and this investigator, Jeff White, because he's doing most of the legwork, right?
Right.
So there was a discussion about this video that she is so focused on. We'll get to that. So that's on sheet 1. So we can start going down this page 1 of these horribly scribbled notes. Hold on, no. Sorry, that was Alexa. She was reminding me of something that I probably don't want to be reminded of. So let's go down sheet 1. Let's go down sheet 1 because we'll get into that 22 terabytes like really quickly. At 8:21, so they started a little early today because the last few hearings have started at like 8:30, and actually I think the one on the 6th might have started at 9 o'clock. Like we were led in the courtroom at 8:30 and they were doing stuff behind the scenes and we didn't even get in there they didn't get started till 9 o'clock. But today we're in there at 8 o'clock. They let the cameraman in. They let the people who are sitting out around the cameraman in. Get started at 8:21. Before that, though, so there was something last week, last week's hearing where the state requested to have some of her biometrics recorded, like her fingerprints, her palm prints, maybe even her footprints, and photographs taken. And I thought they were going to do that today at 8:15, and maybe they did, which is why we didn't get started till 8:21. But they didn't do it in the courtroom. If they did it, they did it behind the scenes. I thought I heard one of the gals in the court saying she's back there talking to the judge. So I don't know if by she meant Lori, but I don't know any other she's that would have been back there talking to the judge. So I interpret what the gal said in the courtroom as Lori was back talking to the judge, maybe in chambers, or maybe she was having her biometrics taken. There was something going on anyway that delayed it a few minutes. At 8:21, judge comes in, all rise. He always says immediately, like within 2 seconds, you may be seated. She was in her orange jumpsuit, handcuffs, shackles, leg irons. And then she requested that investigator, Jeff White, be allowed to sit at her defense table. We've talked about this already. We don't need to rehash it. And then the judge announces that the trial will be moving to Judge Kemp's courtroom. So I'm going to have to do some online research, see which one that was. I assume it's in the South Tower or the West Tower. Crap, I forget. Anyway, I assume it's going to be a much bigger courtroom. So seating will be more than 30. Then they start talking about the juror questionnaire. Is it okay to have Lori's name in there? The state says we need to get out in front of it. We need people to know that this is the trial that they're being brought in to be a potential juror in. And then they say, is it okay to have JJ and Tylee's name in the questionnaire? And the state says, obviously we don't object. And Lori says, I don't object. So I thought that was interesting. Like, she's responsible and convicted of unaliving them and is okay with hundreds and hundreds of jurors seeing them named in a juror questionnaire for her conspiracy to commit murder. The judge says, okay, between the state and the defense, I think we're probably going to have about 21 actual days of trial, depending on the number of witnesses that actually get called into the courtroom, because it's usually about a day per witness. So she has 11, 12 if you count Lonnie Dworkin. They have about 10. So that's about 21 days of trial. That's actual trial days. So if they go 5 days a week, that's 4 weeks plus a couple days, 4.5 weeks. So if they actually get started, so they're going to start jury selection. So they send out juror questionnaires on I think that may be on another sheet. Hold on. Let me look at my notes real quick because we could talk about that in a second if it's on another page. Otherwise, we'll talk about it now. Yeah, that's on page 3. We'll talk about the dates for the juror questionnaire and when jury selection begins and how long they expect it to take. South Tower. Okay. Thanks, Trace. The one hearing they had, the first hearing they had in December was in the South Tower, and that was a much larger gallery with much more seating. But you guys stay home. I got it for you. You guys stay home, watch it on Court TV.
I am. I like my comfy chair.
Right. All right. So now after he says 21 days of trial, they get into this Gilbert PD video discussion. She says, I still haven't presented, I still don't have that from the state. And the state says, we don't know anything about it. And the judge says, if the state tells me that they have given you all discovery and they don't know what video you're talking about, then I don't know how to help you, girl. And I'm paraphrasing, obviously. And she's
in the paths with a
Sorry.
It's all right.
I didn't realize something was going to play in the background. Sorry.
It's all good. So he says, how do you know about this video and how can we get that information to the state so they can either look through their discovery and tell you they already gave it to you or that they don't have it or, oh shit, maybe we do have it. And she goes, well, that was told to me by my mediator. And he's like, okay, well, have that mediator send that to the state. And she's like, well, they can't do that. And he's like, why not? Well, because that mediator is on my former defense team, and my former defense team will not turn over any material, including that video.
A memorial?
So
including
the judge
the video.
said, yes, including the video in question.
That one from Chandler?
Gilbert PD.
I mean, Gilbert, yeah. When we found that we can see.
I don't know if it's that one or not. I honestly don't, because it's supposed to be a 2-hour video. Supposedly there was a 2-hour video in an interrogation room with the camera up in the corner of the room, like we've seen in all interrogation videos.
Yeah, because she said it was on the internet, and when I searched, because I had never seen it, which I knew that they went to. The one I found shows her and Tylee at the desk, but I didn't watch the whole thing. I don't know how long it was. I sent it to you, but I wasn't sure. I don't even think we've reviewed it yet, so I'm not sure. Real quick, she got life for the death of her children because the death penalty was removed from the table in Idaho due to prosecution sanctions. Yeah,
So,
Tammy, JJ, and Tylee.
Yeah. So the judge says he will order them to turn it over. And then we get into a discussion. Let me see if I made any more notes. I didn't on this. So she basically throws her former defense team under the table. And she says, when they left, they did not turn over any material except for that 22 terabyte hard drive. She said they didn't turn over any work material. They didn't turn over anything except for that digital hard drive. So I honestly have a problem with that. Like when that case gets turned over to somebody else, the new legal team, whether it's her or her and her backup counsel, should get everything. Like it's just leaving the door open for there to be some type of well, look what happened in Idaho. The death penalty got taken off the table because of lack of disclosure. So it's a problem. Yeah, Nina Canadian. Yeah, on a previous, I think, morning show that I had, we watched. There was an interview with Melanie Gibb. There was an interview. There was an interview with Lori. There was an interview with Tylee. There was an interview with Jason Mao. There's an interview with Alex. Like all 5 of those, we've seen those interview videos, and I don't know if it's supposed to be one of those or not. Because, I mean, she says it's a 2-hour interview, and I think, I don't have my notes from last week up, but she specifically mentioned her and Tylee and Melanie being interviewed at the Gilbert PD. And she said it's like a 2-hour video. She said, I have 4 12-minute law enforcement officer body-worn camera videos, but I don't have the actual interview room video. So I don't know if that's all 3 of them in one interview room, or if she's talking about like them being split up and being interviewed in different rooms. I don't know, but somebody, her mediator, forwarded that to her and told her it was out there. So she's like a dog on a bone with that. And honestly, rightfully so. As her own defense attorney, she probably should be. But it's got to be sorted out. Either it's there or it's not. Either somebody told her something false, and the judge kind of said that. He's like, you heard this secondhand, so we need to verify whether it's out there or not, one way or another. Right? Trace, does she know any other way to say anything other than whiny and snarky and complaining? She doesn't know any other way. So my handwriting's getting worse. You'll see it just gets worse and worse and worse. Page 3 is even worse. The defendant filed some motions. Witness.
I'm sorry, I was sipping my fresh coffee, and Beach Bum's last comment just cracked me up. Y'all don't make me spit coffee. It may not sound real good.
Can I speak to the manager of the motions department, please? I need to speak to the manager. Judge is like, I'm managing this court just fine. And yes, he is.
Yeah.
Okay.
Trace,
So the
let me. Okay, why isn't Trace up there with you?
Right?
Come on, Trace.
I need to give her a link to jump up here.
You're right, Beach Bum. Coke hurts worse, and I drink Coke all the time too. But it would have been much worse with my Coca-Cola. But I just got some fresh coffee. Probably should have put some whiskey in it for all this, right? And I don't even drink. It put me to sleep.
Have yourself a little Irish coffee at night.
Yeah, buddy.
So the defendant motions, the witness addresses. Okay, so this is the state complaining that they don't have the witness addresses. We saw that in that last filing from Sunday. The defense expert hasn't begun any work. So this is the state complaining that she's not following the rules of evidence. She hasn't provided addresses for her witnesses or a way to contact them at all in any way, shape, or form. And Lonnie Dworkin has not begun work yet. All right. Let's set aside for now, the judge says, the Dworkin issue. Investigator, what is your name? And he says, Jeff. He just says Jeff. And the judge is like, Jeff what? Like, this dude is not professional. He is not professional. My email didn't go through. So that's when the state's like, well, we were expecting a reply email from Jeff. And he's like, oh, well, I left the other day and apparently I forgot to hit send. I'm like, dude, the dog ate my homework. Is that what that is? And then, so the judge is pressing Lori on the state's motion. My dog ate the discovery, right?
Y'all are cracking me up.
The judge is pressing her on the state's claim that she's not following the rules of discovery, and it's very clear that she's not. She says Nate Eaton is the only one on my list that has not been previously interviewed by the state. And the judge says, you mean the state like the prosecutor's office, or you mean like the state like the police departments? And she's like, well, they were all interviewed by police departments. So I wonder how that's going to come into play. And then the judge says Lonnie Dworkin's work is going to take it would take most people weeks, if not months, to do the extraction. And she's like, and so he says, you can't have both a speedy trial and Lonnie Dworkin's investigation starting today or tomorrow or Thursday or Friday or whatever it is. And so he's like telling her, you got to make up your mind. What do you want? Do you want to have Lonnie Dworkin's evidence in that trial, or do you want to have a speedy trial? So he asks her, and this is an important quote right here, if you can't have Mr. Dworkin's report, do you still want to proceed with trial at the end of the month? And she said very quietly, yes. So she's making her choice. The Lonnie Dworkin evidence, she doesn't believe is going to be exculpatory. I'll tell you that right now. Like him extracting Charles Vallow's phone is not going to have any effect on her guilt or innocence. In fact, it may not even be good for her at all. Right? All right. So we have page 3.
Let's take you back to September 28th, 2001. Danielle Bell.
Are you doing research while you're on a live with me?
I am. I'm sorry. I'm multitasking.
I have never done that before in my life, ever.
Well, I do. I'm multitasking. I'm paying attention to you. And I'm gathering materials for something big I'm working on. So yeah, I'm multitasking.
Beach Bum, it'd go bad for her. Yeah, the extraction is probably going to go bad for her because we've seen some of those text messages.
Right.
I just think she wanted to say my husband's phone in court. I want my husband's phone. Honestly, I swear to God, I think that's why she did it. Just so she could say, I want my husband's phone.
See, Lowlight's doing the same thing I'm doing. We can multitask. You're probably right. She just wanted to make that statement, right?
Yeah, and she said it multiple times, at least twice, maybe 3 times. I want my husband's phone. Lady, he's not your husband on multiple levels anymore. All right. So this is the quote of the day right here. Yeah, she's got to have stuff to complain about for sure. Oh, Trace, you and I are going to have a live to talk about our courtroom experiences one day. Maybe we need to save it till we get a couple weeks into the trial. Maybe we need to have one like weekly during the trial. There's going to be so much to catch up on.
Y'all going to need some therapy after all this is over.
Well, I love the fact having her there with me while I'm taking notes, because I've got my notes and I'm trying to keep up, and there is no way I can catch everything. And there's no way I can get everything right. So having somebody else there with me who's intelligent and paying attention and knows the case is so helpful and awesome. All right. So this is the quote of the day, though. This is the quote of the day. Judge Beresky says to her, you can't have it both ways. You can't have the speedy trial, and you can't have your expert's report come in a month down the road. And she says, and he says, according to the rules of evidence. And she says, I understand it's a rule. And I also understand how unfair and prejudicial that is to me. Like, she says it like that. I understand how unfair and prejudicial that rule is to me. I was like, whoa. And then they start talking about if she is going to testify. And the state asks her, "Are you going to testify?" And the judge says, "Are you prepared to make that decision now?" And she says, "Of course, no, I'm not prepared to make that decision now." So start talking about what if. Sorry, dogs started going nuts.
Mine did too. I had to let her out back. She like there was something out there.
So if she testifies, the jury will hear about her convictions, but they may not hear about specific things that she was convicted with, like that she was convicted of murder in Idaho. They will hear her that she does have convictions, but he said, "I may sanitize the jury so they only hear that you have convictions and not what those convictions were."
Right.
I have mixed feelings about that, but I think that's in the defendant's interest.
Yeah. I mean, there's always protocol about juries anyway, and the questions and different things. So they have to come up with a cohesiveness between the two parties and with the judge as to what, can be presented to the jury. Because we just went through all this in that dang Idaho 4 case with all those jury questionnaires being sent out and the weird questions they were wanting to ask, things that they shouldn't have been asking. And the judge even pointed that out, right? But these are not unusual stuff. But yes, some of it, I mean, you can't hide a lot of her past. But like in the Koberger case, we know there's the one incident we do know about, like the stealing of his sister's phone, that won't come into court. The jurors will never hear about that. The jurors won't even know about it during questioning. So you don't want to prejudice too much against the defendant, but because I think the evidence is going to stand alone. You know what I mean?
Yeah.
Even if they didn't know anything about her prior stuff.
Absolutely. And we know it will.
Yeah.
And then, so this is relevant to recent cases too. We saw in Sarah Boone's case, and we saw in Robert Tellis in Las Vegas, the dude that the real estate agent that unalived the newspaper reporter. He got to testify in narrative form on his own behalf. Like the judge just let him go. And there were a lot of people watching that trial that were like, how does he get to do that? Judge Beresky's a little smarter than that. He's like, okay, you got to write out your questions ahead of time, and your either backup counsel, your co-counsel, or your investigator or your paralegal, somebody, not you, is going to have to ask you those questions and elicit those answers from you. She's not going to be allowed to just get up on the stand and just go. So Beresky, I like this guy a lot. And that's another thing. So we'll see down here at the bottom of the page, he's planning on being the judge for the second trial for Brandon Boudreaux's conspiracy to commit murder trial also. And I'm glad he is, because if you throw Lori to another judge, who knows what kind of a shit show that's going to turn out to be? Who knows what kind of a circus that's going to be? So Beresky is changing offices. He's rotating to another circuit or something in July. So he said today, we are going to start the second trial for Brandon Boudreaux, the 2022 case. We're going to start jury selection May 30th, and we're going to be done by July 4th, period. So he's like, I'm going to be the judge for both cases, and we're going to get it done all by July 4th. But dang, that means we're going through July 4th with Lori Daybell representing herself at trial. Buckle up, folks. Buckle up. She had some motions to file. I checked online right before I went live, and I didn't see anything posted yet by the court clerk. But she had a few motions to file. And I guarantee you, so if you look down at the bottom of the page, they're going to meet May 30th for the start of July selection in the Brandon Boudreaux case, 2022 case. She goes, when is that going to start again? And he wrote down May 30th. And I guarantee you that she's going to file a motion for her right to speedy trial being violated because it's May 30th and not May 11th. I guarantee you there's going to be a motion for that. Like, anybody want to bet me? Like 25 cents, $100. Probably shouldn't bet anymore on Lori because all bets are off with her. So the jury questionnaire is supposed to go out on the 20th. The jury, so they're going to meet on March 31st. God, my handwriting is so crappy when I get in there.
We got to fix that. Let Trace start taking all the notes.
Right.
I'm teasing. Trace, he can't read his own notes, honey. We got to do something about that.
So jury questionnaires go out the 20th. They're going to meet on March 31st to review the questionnaires that they have got back. And then actual jurors will come in for voir dire on April 1st, which I find highly ironic. Again, April Fool's Day. Lori's going to start voir
We got
diring
a
some
shout
jurors.
out, Joe.
Young Black Economist, what up? What up? Thank you so much. I appreciate
Okay,
that.
$2 on the table, Joe. I love it.
All right.
That's awesome.
Oh, all right. It's on. The bet is on.
It's on like Donkey Kong.
$2 holla.
I got to stop drinking coffee during this damn stream.
You're going to be all hyped up by the time we get done.
Oh, I drink coffee all the time. I'm always hyped up on something. Not on something that came out wrong. I'm always hyped up on caffeine. Let me rephrase that. Between my Cokes, my coffee, and my goodie powders, I am a caffeine freak. I think I'm addicted.
All right. So jury selections began on April 1st. Let's see. The 31st. If yesterday was the 17th, so the 31st would be 2 weeks from yesterday. So that's when they're going to meet. They're going to meet on a Monday, go over the questionnaires that they've got back. They don't expect that all of the jurors will have returned the questionnaires. They're going to start with 200 questionnaires. And then on Tuesday, so in exactly 2 weeks, then they're going to start voir dire. They expect it to go a week. The state actually expects it to go longer than that. And if you listen to Lori in the last trial, she said, we had to go through 1,900 potential jurors in my last Idaho case. So we may not see actually Judge Beresky have the second, preside over the second trial if juror selection lasts much longer than that, than the first week of April.
And it's not unusual to have that many jurors brought in to weed them out. You know what I mean? It's not.
Yeah. So if we can't hear the audio on this, I'm going to be...
Oh, Lord.
Here we go. Here we go. We're rolling the dice. We're rolling the dice. Let's see. I'm going to mute and then unmute. Tell me if you can hear this or not.
Okay.
It's an incident that
We can
occurred-
hear it.
It's not really, it was disclosed because it is mentioned in the defense filed a motion for.
So this is talking about that video from Gilbert PD that Lori swears was a 2-hour video that the state hasn't disclosed to her.
The state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
So she says that disclosure is complete. Lori has said her mediator told her there's a video out there. The state says We looked for it, and we don't know what the heck she's talking about.
Maybe
Our
she ought to go through
disclosure.
those terabytes she's got. She might find it.
Right. And that's actually a point that the judge made today. So crap, I didn't go over that in my notes. When they were talking about the extraction of Charles's phone, the judge said, or no, the state said that extraction is in that 22 terabytes. That extraction's in there. Like, you already have that. And the judge looks at the defense table, which includes Lori and her backup counsel, and now the investigator, Mr. Jeff, and says, well, can't you copy that and get that? Couldn't you have gotten that to Lonnie Dworkin by now? Like, just because they haven't approved him to be working on it yet doesn't mean you can't copy that and get that extraction to him. And Jeff goes, 22 terabytes? And the judge goes, yeah. Like,
Well, let's see. How many terabytes did Delphi say they had? I know Ann Taylor has named, God, I can't even remember how, 65, maybe more than that, terabytes. And it's like the more these cases come out, we're hearing about all these massive amounts of terabytes. Y'all need to start getting better at going through it all, is all I can tell them.
yeah, I mean, they should have duplicated that 22 terabyte hard drive by now.
Yeah.
I mean, 22 terabytes used to sound like a huge amount of data, but it's not anymore.
Exactly.
Not in
And with
today's world.
in today's world, exactly, with all the data, phone extractions, car extractions, all these different things that computer extract, all the data, video cams from around town of cars being, all these things. I know a lot of defense attorneys lately have complained that they get these discovery dumps and there's nothing labeled or organized. And I understand that. That can be a pain in the ass probably, but y'all better be prepared for the future if this is the way it's going to be, right? And you can't keep coming out screaming you don't have discovery when you come out and tell us how many terabytes you got that you can't make it. Ann Taylor's like, it's going to take me 3 years to go through all these terabytes. Well, then, honey, apparently you did get some discovery.
Right. And no, it's not going to take you 3 years.
Well, according to Ann Taylor, it would.
Right.
Guess what, Ann? You're going on 3 years now, baby. I bet you got that just about done with, huh?
Right?
I mean, come
She's
on.
down to the last terabyte. Right now, she's down to the last terabyte.
Damn, they got that car. We didn't just like, oh.
Any comment on that?
Yes, Your Honor. For clarity, is this?
I honest to God hope that the cameraman for the court pool feed when we go to trial is better than this guy. And I met him, not like personally met him today, saw him, and just the zooming and the panning and just like, lay off, dude.
Yeah.
And I understand he's
that was
kind of got
mentioned in my chat earlier. I forget who brought that up actually, that, you know, about the zooming, because we noticed it during the trial. Or I kept saying trial today. I'm in the hearing. But yeah, we noticed it as well.
Yeah, dude, just like
Shoe
find a spot,
cam.
stay there. Yeah. We actually, Pokemon actually mentioned that to one of the court assistants today, right?
Was that
Trace?
foot going this time? Like, like it was the other day in her other hearing?
This gal that works in the court is off to the left side. You can't see her right here. I think she pops up from time to time. But when the cameraman's setting up, she walks over to him and she's like, you know what? Whenever you're panning in my direction, if you could just like not pan on me, I would be, you know, grateful for that. And she's kind of joking, you know, it was in a joking way. And I was like, I looked at her and I'm like, well, that's a good time for him to zoom in on her feet and her ankle cuffs.
And Trace, you make a good point there. She says maybe they need to slow down and not be in such a rush for trial if they don't have enough time to go through this stuff. And, you know, that was brought up over there with Ann Taylor's like, you're forcing us to waive our right to a speedy trial because of all of this evidence you've dumped on us. Well, welcome to evidence land, honey. You waive your right to speedy trial, gives you plenty of time, right?
Well, the judge confronted Lori about that today. And he said, you have a choice. you can either waive your right to a speedy trial, or you can present your case with whatever evidence you're ready to present it with. And
Right.
that's why I like the state's filing from Sunday, because they said she agreed on March 11th that she was ready to go to trial on March 31st. She agreed to that already. So her going in court today and whining and complaining and saying that she can't have all the evidence she wants, she could have said that a week ago. She could have filed for continuance a week ago. And then I wouldn't have extended my stay here
It
in
ain't
Arizona.
like she's going anywhere, is it?
Right. No.
She's not getting ready to fly off to Hawaii anytime soon.
Is the state proposing that there is no video, or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not.
So attached to that DR number, that just means that she's got two cases. She's got the DR 2021 case, which is Charles Vallow, and then the DR 2022 case, which is Brandon Boudreaux. So she's just saying that if she filed for discovery and she only put down one of those cases on there, is the state refusing to provide it because it was for the 2022 case and not the 2021
Right. And
case.
if it pertains to Brandon's case, she doesn't need to get it. She has no right to it in this case. This is Charles's case. So any discovery that's over there in Brandon's case does not pertain to Charles's case. Totally separate.
But a lot of it can overlap, though.
Well, I mean,
Like-
I get that. But if there's something particular that's in his case, she can't say, oh, give me that too. Not unless the state's going to use it, right? If she has the right to go up against whatever the state's going to do, that's her right. But if that's actually something going down in the other case that they're not using in this case, then she's full of shit.
Yeah. Well, that goes without saying, even though we love to say it.
Where's the
She's not
shitty
aware
movie?
of
Right.
what video
Right.
you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why?
Oh, wait. She just said a mitigator showed it to me. I was under the impression the mitigator just told her about it. So that's interesting to me, because if she actually saw something that was a 2-hour interview in the Gilbert PD.
But she was there. She should know if it was real or not. I mean,
Right,
she
yeah.
actually was there.
Right.
So she knows
True.
it happened, but she's just crying because it's on the internet now. Well, honey, a lot of your stuff's on the internet.
Well, she's crying because she says the state hasn't provided it to her in discovery. So,
Well, if they're not going to use it in this case, it don't need to be in discovery. It has to pertain to this case.
okay, I see what you're saying. Yep, okay. I gotcha. I'm picking up what you're throwing down.
Oh, good. That's funny.
Why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
Because of a conflict.
What is that ring on her ring finger? You see that? It doesn't look like malachite.
Well, I can't
Did they
see it
take
good
that
enough.
from her as they took that from her as a possession, right? So she had to make up one in jail to
Yeah,
wear?
because usually they take all your stuff and put it in the box until you get out of prison, but she ain't never getting out. So I don't know if they would take your wedding rings. I don't know if they, I mean, I think they do take all that kind of stuff, right? But she probably has her little homemade jailhouse wedding band. Prison ring, Hokey Mom called it.
Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
This is a pretty big deal right here. This is where she throws her former defense team under the table, and her current backup counsel has to like think about what did we get and what didn't we get.
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn down any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
That was an interesting little look there by the backup counsel. And this is right before she gets up and goes over and talks to the other backup counsel that's seated to the left of the investigator. So the investigator is right there in front of us. And Trey said that he has bedhead. That's not bedhead. That's an intentional hairdo. He's like fluffed it out when he got up this morning and prepared for court. He like fluffed out his hair. It's not bedhead. That's his actual intentional hairdo. But she's going to get up and walk around and talk to the other backup counsel, which we can't see off screen here to our left. And they're going to discuss what Lori or what their team got when the other defense team was fired or resigned or whatever the heck happened, and they took over.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. To makes Hicks, you look like you want to say something.
I don't know.
Yep, there she goes. Oh, I'm almost on camera. I'm right off to the right here.
Uh-oh.
I'm like three feet off to the right. They're playing the whispering.
Some questions.
Did you hear that?
Yes, I did. Some questions.
Oh my gosh, how is this guy still the cameraman? Like, he should be fired immediately for not muting out his mic.
The defense is supposed to mute out their mic and not if they're going to whisper to each other.
No, there's no mic. So the backup counsel is literally sitting right in front of the camera, and he's got a boom microphone, and he told the judge that if
they start whispering, he'll turn it off?
Yes. He said the only audio feed that he will play is the court microphones. And there are no court microphones picking up this conversation. It's his boom mic. And he told the judge that his boom mic did not pick up any audio. Obviously, that's a flat out lie. No.
It was an accident, Joe.
No.
Oopsie.
I'm not okay with that.
We got Joe riled up, y'all.
Yeah.
But let's go back and hear what they whispered about.
Yeah, let's do. If they say that, don't they have to what?
What?
We gotta play it again. Turn up your volume. See if you can tell me what they're saying.
I'm trying. Put my good ear up. If they say that, don't they have to prove it?
Oh, we need to do a short on that.
I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about.
He's going to get cameras thrown out of the courtroom.
Their entire file.
Well, don't do a short on it in case they catch on to what we know about it. Isn't there a microphone at Lori's table just like there is at the other table? Yes, there is.
Yes.
See it right there.
Yeah, there are official court microphones there, and that is supposedly the only audio. Him or those two, so prosecution, defense.
But how do you know that they didn't reach out? Okay, devil's advocate, how do you know that Lori didn't reach over and not hit her mute on that mic? We see it in all
because
of the
because the level of whispering would not have been picked up by that microphone. No, I was in court and I couldn't hear it. So, and I was 7 feet away from that microphone, from her microphone. No, nope. That was the boom microphone on that camera. 100%. That was the boom microphone.
boom away, dude. Let me hear her secrets.
I do want to go back and I do want to like put together a transcript for that.
If they say it, they gotta prove it. Is she looking at you, Joe, right there? Did she look at you?
I think she was giving the state side eye.
I think she's
It's like-
giving you the side eye. She's like, where did this guy come from? And why is he suddenly showing up at my hearings?
My name ain't Ned, Lori. My name is not Ned.
No, it's Stan. We're going to call you Stan. I think this woman actually thinks she's got a shot at beating this.
Yeah. Yeah. I did appreciate these quiet moments in court, though. Like when the judge is doing his paperwork and stuff.
Did you nap?
No, I tried to catch up on my notes, but
Oh, okay.
so we're talking about the Chandler videos, but I swear, because I was taking my notes in the moment, that Lori is talking about a Gilbert PD interview.
That's what she brought up in the last hearing.
I don't think it's Chandler. I think she's talking about a Gilbert, and maybe she's mistaken.
Nina
Maybe she-
Canadian dropped. What is it? Would read her comment there.
Yeah, so she's got a lot of different interviews on there, but I
did find one though from the other one, but I don't know if it's the same video.
Yeah, I swear they said Gilbert because I was writing it down like real time when they're talking about it in court. I wrote down Gilbert PD.
That's
and
what she said in the last hearing. Mm-hmm.
Yeah.
Yellow light. He is planning to do the whole trial, right, Joe? You are planning to be there for the whole
That is
trial.
affirmative. That is affirmative. I can affirm that plan. I can't guarantee, but I can affirm that's my plan. And I have made extended plans to stay here beyond. I wintered here, and I'm not looking forward to triple digits, but I'll be here as long as it takes.
You
even
gonna
into
come to?
triple digits.
You realize we have triple digits in Florida all summer long.
Yeah, but if you're on the coast,
That's different.
like I don't. Yeah,
you get that sea
I would.
breeze.
Yes, I would never live in like inland Florida. Like,
Oh God, me neither.
yeah, no,
Yeah, no. I can't be landlocked.
yeah. So yes,
Tallahassee's like that, and I'm not down with that. I got to be right here by the water.
right.
It's my happy place.
I don't know what he's thinking about. He's looking at some stuff. I think he's getting ready to say something.
And well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator.
Jesus, cameraman. Holy cow. I honestly think I could do a better job, and I did a horrible job after court today. I tried to go live, and it ended up being a private video. Like nobody could watch.
Joe, from your phone.
Yes, from my phone.
Oh,
So remember
no.
last time I couldn't do StreamYard, so I tried going live directly from YouTube, and I guess there's a setting that has it automatically set to be a private video, and I'm like, I get
Well,
back,
yeah, you got to set it to public, private, or whatever. There's three
Yeah.
options.
and I didn't do it right, but that's okay. We still got jury
Learning
trial to get it
curves.
figured out.
Yeah,
Yep.
learning curves.
Sent over a list of the,
But I'm also not a professional cameraman, and so his learning curves are a little frustrating for me right now.
Well, the judge might as well go ahead.
Address-
But isn't this supposed to be the last hearing, though? So I guess it doesn't matter now. But he should have went ahead and implemented his camera rules,
Right. Yep.
This isn't trial yet, so I guess today he's like, whatever. It's last hearing. Y'all just do you. I don't know.
Well, he doesn't know what's being aired. Like he has no
You're
idea
not-
until
Right. And see how they zoomed in on the prosecution table, even like on the shot you got right there, you can see her laptop open. That's the same
Yep.
thing they're not supposed to be doing.
Yep.
They're not supposed to
100%.
be doing that.
addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own self-right or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded.
Oh my gosh. Look at her. Her eyes are closed. Her fingers are like stress pressing each other back and forth. She is so frustrated with this already. She is so frustrated with this already, with Lori and the nonsense. Like she's trying to maintain a professional demeanor, and I can appreciate that. But Lori stresses her the F out. I guarantee it.
Yeah, she wouldn't stress me out that bad. I wouldn't let her take up that much space. Maybe she's just,
Well-
maybe that's her natural way when she thinks or something.
Well, but she's got to maintain a professional decorum, and legal details matter.
Most
Like
of
how
them
she-
do most of the time.
Yeah.
Sometimes they lose their shit, but I don't know.
Right.
Let it play so I can finish watching her though. She might
Alrighty,
decide
alrighty.
it's
From
her
law
normal
enforcement.
way of doing things.
I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you,
Did you catch that, Jeff? Okay, Jeff who? Why would you announce yourself in court with just your first name?
I don't know.
We're
It's
gonna be
Lori's
setting up
defense.
interviews
It's Lori's
for the
defense
state to
team. What do you
to
expect?
Interview whatever potential witnesses the defendants noticed.
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that this is the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay.
And
When you
Jan.
say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things.
Did you catch that whining? I'm a convicted triple murderer, and I have to be locked down 23 hours a day. The level of, I don't know even what you call that. What do you even call that? Like what? Husband is dead. Brother is dead. Children are dead. And I'm locked down 23 hours a day.
Getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these
Well,
people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
Ooh, motions in limine.
All right, so it's premature to address these today.
Yeah, I mean, we're talking about all kinds of procedural things that have to happen in court that are going to take weeks, if not months, to get through. Right? Like motions in limine. So we have to know who the witnesses are. The state has to have a chance to depose them. The state has to have a chance to file motions in limine. Like I was really, really honestly, seriously worried today that we were going to have the trial continued. And it still may be continued.
If
But
they
we're
start
gonna-
filing motions in limine, it will have to be.
Yeah, absolutely.
Let me check up on chat here for a minute. I was multitasking and I ain't been paying y'all no mind. Sorry.
You're all good. Yeah,
I got to talk to my people.
I just have this really, really strong feeling that this trial is going to be continued.
It might. We'll see where it goes, right?
It depends on if Lori is willing to surrender her witnesses, including her expert witness.
Well, she has to.
Well,
You have
I
to
mean,
disclose. I mean, you have to disclose the information, but
right, no. She has, and we went over that motion. You know,
yeah,
that was back a couple weeks ago. But I mean, by surrender, I mean by give up the right to present that in court. Because
yeah.
if she doesn't, if she doesn't give the state ample time to examine those witnesses, including the expert witness, before trial, then the judge can just throw it out. He can preclude them, all of them. He can just say, hell no, you did not provide those with enough time for the state to respond to it. So you don't get to present any of that. So if she's willing to say, okay, none of them are really going to do me any good, then we can proceed with a speedy trial. But otherwise, if she wants to use any of those and the state hasn't had the proper time to examine them, then we're not getting a speedy trial. It's one or the other, and that's kind of what he says here in a little bit.
The state's going to have to
yes, Lisa. Joe is
interview
going to
them
trial.
and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up.
Well,
But if they're unable to be located or interviewed, obviously they won't be called at trial.
Hear that? That's just what I just said. Sorry, Judge, I didn't mean to step on your toes there, but I'm going to let him say it again his way, not my way.
Located or interviewed, obviously they won't be called at trial.
Back up a little more.
Interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up.
well,
But if they're unable to be located or interviewed, obviously they won't be called at trial.
Oh, did you see that look? Did you see that disappointed look she just gave? Oh, watch this. Watch her look down to her left after he tells her that if the state can't find her witnesses, they won't be able to be called at trial. Watch her look down to her left. She just got told what's up.
They'd be called, I'll have to deal with that as it comes up.
well,
But if they're unable to be located or interviewed, obviously they won't be called at trial.
See that look? Oh, I love it.
Mr.
And
Dworkin,
Lisa,
if you
yes,
want
there
him
are going to
to
be cameras.
do extractions, you're not ready for trial.
Court TV has been appointed to be the pool camera supplier. So I actually inquired with Maricopa Court, and they said I have to go through Court TV to access that feed, like if I
Yeah.
wanted to air it on my channel. So I'm waiting on an email back from Court TV.
Wait. What do you mean? No, once they air the trial, anybody can air it. What exactly are you saying here? I'm confused.
I'm talking about live. Like there'll be a
But if
delay.
you'll be at trial, so how can you stream it live?
I don't know.
I'm confused about what you're saying.
We'll have to figure that out, won't we?
I'm gonna air it. I mean, I don't need Court TV's permission to play it. I'm confused. Am I not? Am I not understanding?
I'll let you know what I have in mind off channel. Back channel.
Okay. Because everybody's got to
So-
get it from Court TV, and everybody can air it.
In order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th.
Well,
from OPDS.
you're the one pressing for
Hey,
your
Joe, hold
speedy
on a
trial,
second.
so you kind of have to make a decision.
Yeah,
Um,
go.
I think there's some confusion. Like Lisa, she says, I don't know. They might like demonetize that episode. Honey, anytime Court TV airs a trial, everybody covers it. So if they demonetize it, then that's fine with me. I don't care. But I don't think that's possible because everybody, I can air it from Court TV. East Idaho News will be airing it off that pool feed. There's a lot of places that are going to be covering it. So we can't get in trouble for playing the trial.
Right,
We
but
can't.
there's another feed besides just like replaying their YouTube channel on your channel. There is another feed that other providers should have access to. Like we shouldn't just have
Yeah.
to replay Court TV's stream on our YouTube
That's
channel.
that's what I'm saying. Court TV doesn't mind. Like Pokemon says, they want people to use it. They know we're going to use it. And I can literally stream it from anybody who Law and Crime is going to be streaming it. East Idaho News, all from that feed, right? It doesn't mean Court TV gets the rights to that trial. That is not what that means. They were just approved to do the camera. That's all. And then it goes out to the pool feed. Then anybody can use it at that point.
Right. All right, I think we got that square.
Yeah. Y'all seen how many
Decision
trials that we're out there watching daily. I mean, everybody's streaming trials from the pool feed, right? And nobody's in trouble for it.
We're set for trial. You want to go
The
to trial, or you
cameraman.
want to have him do that work that you want? Because I don't think both are going to happen.
Hear that
Even
again.
if you got the
We're gonna hear that
laptops
again. I don't think both are going to happen.
And I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision.
Oops, you're the one that's pressing for speedy trial, so you kind of have to make a decision. That's one of the biggest deals in this hearing to me.
On we're set for trial. You want to go to trial, or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but
Did you hear how her voice trailed off there? This is like the meekest I have heard her since I've been watching these hearings. Her voice just trails off.
You didn't hear her whine in her Idaho cases, did you?
I didn't follow them as closely as I am this. I will admit that.
And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting.
This cameraman seriously needs to learn how to pan and zoom smoothly. Like, he's bugging the crap out of me.
Well, pick your battles, man. Pick your battles.
It's either her or him, right? All right.
Like, don't let it all
Okay.
stress you out, Joe. You don't even need to go to trial if you're going to be that stressed out on me, man. Come on.
Right. Well, you said you saw how neatly I take notes when I'm stressed out.
You don't got to be such a. Okay, I understand wanting to take notes, but if it's the trial's going to be aired, you shouldn't have to take as many notes, right? You just want to write down the most important key points to you.
Yeah, and that's kind of what I did today. I did a better job of that today, I would say, because I only took 3 pages of notes.
I'm sorry. Comments are cracking me up.
Yeah, Trace. Yes. Lonnie Dworkin has nothing else to do. I'm sure he's just sitting around twiddling his thumbs, waiting for Charles's cell phone and whatever laptop she has that she wants him to look at.
Items here impounded by a particular police department or items that may be impounded in Idaho?
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone.
She definitely said Chandler. So I wrote it down. Oh no, Chandler has the cell phone. Gilbert has the video she wants. Chandler has Charles's cell phone. Okay.
Right.
Now I'm straight.
Charles Vallow's phone.
Did she say my husband? We got to hear that again because it's so disgusting to me.
We're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone.
No, lady. No.
Charles Vallow's phone. And I would like a copy of the extraction that they took from it, the digital forensic.
She has that on the 22 terabytes. I guarantee you she has the extraction that they took from his phone on the 22 terabytes. And I think the judge recognizes this now. So this is actually a very relevant conversation between them.
Extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
What's up?
Boom. Wasn't that already disclosed? Yes, Your Honor. Shut up, girl, and go check your 22 terabyte hard drive.
Part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So hard drive.
So now he's whining. Everything I have is on a 22 terabyte hard drive. I don't even know. She's even got him whining now. Did you like that? She's even got her investigator whining now. 22 terabytes is not that much in today's world. It's not, dude. You're the same. He looks like about the same age as me, right? How old would you say he is?
From the back of his head?
Yeah.
60-ish.
55 to 60? Yeah, he's not that much older than me.
He's around our age.
He can figure out terabytes. I've figured out terabytes a long time ago. Stop whining, dude. It's contagious.
Need to get a new job, dude.
So
if you
if
can't
I
handle the
give that
terabytes.
away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
Dude, I got to play that again just because that is so freaking lame. Like, it's lame enough that I almost wanted to drop the F-bomb, and I'm not going to do it. That is so lame, dude. You are an investigator. You should know about digital files, hard drives, making copies.
So hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
22 terabytes. Oh my God, it's so much. Judge is like, yeah, I understand. 22 terabytes. Judge has it figured out. Judge is probably about the same age. He might be a little bit younger, but he knows about terabytes. Judge says, I understand that.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
This is
Oh,
no. Go
Go
ahead.
ahead.
Go.
no,
Go.
you're laughing at something different than I'm laughing at. So you go ahead.
Yes. The judge rolling his eyes. The judge's eye rolls I did not catch in court. And he is doing some serious eye rolling right now that is cracking me up. Like
Kind of
every
like
time
Judge
that,
Hippler when he gets that look on his face over there in Idaho. They're like, "Damn it, man, we really got to put up with this."
yeah. What were you laughing at? Come on.
Comments in the comments. Trey says she'll make us. I'll make y'all pot stirrer avatars. Which you had to follow the conversation, I guess.
Yeah. No, she told me about pot stirrers today.
Oh,
on
I
the
see.
way-
Okay, I
on the
get
way
it.
to
I see
court.
now. She
Yeah.
made another comment. Got it. Okay.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Key question right here. This is the question of the hearing today. Key question. So you're trying to get your expert, Lonnie Dworkin, to do cell phone extractions, maybe laptop extractions that may take weeks or months, but you're also wanting to have a speedy trial. Which is it? Which do you want?
Yep.
So pay attention, girl. Pay attention to what the judge has to say here while he's rolling his eyes. You see that look on his face right there? I backed it up to the perfect spot.
Oh, my Lord.
I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
that eye roll.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
See how meekly she said that? But she was ready with that answer right now. She's like, speedy trial over evidence. What does that tell you? What does that tell you? Speedy trial over evidence. That says a lot.
Your Honor, I would ask leave that depending on what Mr. Dworkin says, that
Well,
would
it
put
could
this,
still be precluded because
Oh dang! Oh, we got we got the foot zoom. We finally got the foot zoom. Trace, do you see that?
Dolphin was like, "What? No, she don't even get padding around that chain." I'm like,
No.
she don't need no padding.
We got the obligatory foot zoom, Trace. There it is right there.
And that's a pretty hefty chain, isn't it?
That is. That is.
She got them shower slides on.
depending
Don't
on
wanna
what his
catch no foot
opinion
funk.
is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
more than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Judge taking a drink, saying, damn, I wish there was vodka in that.
I was about to say, has he got vodka in there, Joe?
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No,
Oh, snap. Snap, Judge. My housing precludes me from that. She's talking about investigation. He says that precludes you from filing a continuance. Well, no, no, it doesn't. You can file for continuance at any time you want. This is counsel for the defense.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay.
She forgot the word efficient. Effective and efficient manner.
Well, she lost her words for a moment.
Yeah, I think he's got her a little bit stymied. I really do. I think he's got her a little bit flustered.
Because she don't know what
All right,
she's doing.
Well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
All right. That's the second quote. The second biggest quote of the trial. It just like tells you everything you need to know about this human being. Saying that loosely. I understand what the rule is, but I understand how unfair and prejudicial the rule is to me. Like, you got to hear this, people. You got to hear this.
Don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay.
And he just goes, okay. He just goes, okay. This guy has a bucket of patience that I don't have for this woman.
So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then? From
Your Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions.
He does so much eye rolling that I did not catch in person in court. Like,
Because she was looking at Lori.
No, I wasn't. No, I wasn't.
Was admiring her hair.
She did have better hair today than she did a week ago. Like last week, she just like pulled it all up and like put it on top. And today it was a little better. So she must have gotten up at like 6 o'clock to get that hair done right before she came into court.
I'm sure somebody helped her.
She can always find somebody to help her, can't she? It's like she's that person. She is that person that can always find somebody to help her.
But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write.
Okay, this is pretty important here because like we discussed when we were looking at my notes, she can't do a narrative defense testimony like Sarah Boone got to do, like Robert Tellis got to do in the Las Vegas trial. She's going to have to write out her questions ahead of time and have one of her assistants there question her on the stand specifically as to the questions that she has written out ahead of time. Britt, is she asking for Nate Eaton to be questioned? He is on her defense list. When I saw him a week ago, he had not been served with a subpoena yet. So we all are just wondering, like, what can she possibly question him about? Like, no idea. That's out there in La La Land somewhere. But that's where Lori lives. Lori lives in La La Land. So I reckon we'll find out sooner or later. He's from East Idaho News, and we know she is a triple murder convict in the state of Idaho, and he helped to track her down when she and Chad went to Hawaii. Not just help track her down, he did track her down. So the relevancy to this case, to Charles Vallow's murder, is really mind-boggling to me. But she also included both case numbers in that filing, not just the 2021 case. So the 2021 case is Charles Vallow's, her conspiracy to commit felonious murder, F1 murder of Charles Vallow. The 2022 case is her conspiracy to commit felonious murder, F1 of Brandon Boudreaux. So it could have to do with either one of those cases. But she actually testified today relevant to the 2021 case. So we're all stymied as why she has Nate Eaton on her list, unless it's just like a grudge thing. And actually, when he came into court last week, I asked him, and I've said this before, but I'm going to brag about it like probably 40 times more. He walks into the gallery behind me and Trace, and I'm like, should you be here because you're a potential defense witness? And he goes, I haven't been served yet. So no, he can be there. But obviously it doesn't make a whole lot of sense. Nate Eaton being on the defense witness list makes almost no sense at all. But we're not in her head, so maybe she has something in her head that will explain it.
Thank God we're not in her head.
Yeah, right?
A dangerous place to be. Could you imagine?
Nope, I don't want to.
It's one head I can stay out of.
Yep. We got about like 9 minutes left on this, and I think we should play it to the end.
Your questions that you want to be asked, and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response.
Wait, did he just say we're going to have a 609 hearing?
I think so.
So maybe this isn't the last hearing before trial. Maybe.
No.
This is the last status hearing before trial, and then we're going to have jury selection. But a 609 hearing, I need to research that. Hold on. I got to take notes, guys. All right. Carry on.
I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing.
I found it.
All right.
I have some motions that I'd like to file. I've had a real
Wait, what? What did you find?
Okay, a 609 hearing refers to a legal proceeding governed by Arizona Rule of Evidence 609, which deals with the admissibility of a witness's prior criminal convictions to impeach their credibility.
Okay, so whether or not the jury's going to hear about her murder convictions in Idaho.
Right.
Okay. That makes sense. But, so I wonder when they're going to hear that.
Probably soon if they want to keep the trial on track. You know what I mean?
Right.
He didn't announce like anything that like at the end of this hearing, he didn't set that up already. So, that I know of, right?
No. Nope.
Yeah. So he'll make a ruling and probably decide when and if they're going to actually do that.
So now we know 609 hearing. Thank you, Salty.
You're welcome.
I had a really hard time getting, my paralegal
copies
is
for the
very
state.
busy. I don't have copies.
All right, we'll make copies.
She has filings, and the freaking cameraman should not be zoomed in on her freaking court filings that haven't been filed yet.
No, they shouldn't.
Dude. This guy, like,
Copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10.
so he said remote responses. I wonder if the juror questionnaires are like sent out via email. Like, do they pick out potential jurors? They have their email addresses? Because he said we're going to go over them over the remote responses. He didn't say we're going to go over them remotely. He said we're going to go over the remote responses.
Yeah.
So I'm curious what a remote juror questionnaire response is. Really curious.
Well, they may be, I don't know. They usually mail them out in the
Right,
beginning.
yeah.
Maybe they're
Yes.
maybe they're mailed back in or emailed back in. You know, they may have an email attached and say, hey, you email it back here. I don't know.
There you go. Yeah, because the state did say last hearing, the state said we don't expect everyone who gets sent a response to have it completed before they come in. They should have it completed before they come in, but we don't expect they all will. Some of them will bring their responses in like physically in hand when they come in on April 1st. So that's going to be interesting. I'm really, really interested in seeing Lori voir dire some jurors.
Right. She's going to be like,
I'm-
y'all know who I am. Have you seen me on TV before?
I'm going to give me a pair of those Google glasses. No, I'm not. No, I'm not.
True grit. Where you at, girlfriend?
Because that is going to be a fascinating back and forth. Oh my gosh.
It's at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
Yeah.
Okay, well, see his hair? He did that on purpose. And that's why I told Trace on the case that That's not bedhead. That is him. He did his hair that way intentionally. That's like the Peter Pan look. I'll call that the Peter Pan look. Jeff, we see you there. Tried to stay forever young. See, okay. See, they're whispering right here and we can't hear it. That's why I know that conversation, that whispered conversation we heard earlier was the boom mic on that camera, on that courtroom camera.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to need to go into the next week or not. That reminds me, though,
that's a pretty big deal because there's a discrepancy between how long the state thinks jury selection is going to take and how long the judge thinks jury selection is going to take.
Well,
And
he's got plenty of trial experience. He's basing it on that. You know what I mean?
Right. And she's basing it on this crazy woman sitting at the other table.
Yeah, exactly.
Where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to.
Is the judge Mormon? You can't tell just by looking at somebody. There are a lot of Mormons in the East Valley, east of Phoenix. Don't know where he's from, and I don't know his religion. But at this point, I don't think it matters because I think he's handling her very well.
Yeah, it shouldn't matter. Honestly,
No.
if it's a problem, he needs to be removed because it should not matter.
Well, she's not Mormon either. I mean,
Well,
seriously.
no, I mean, I'm just saying, that's you know what I'm saying.
Yep, I did. Yeah, I got you. Yeah, it's.
You can't let when you're a judge on the bench, you're not supposed to let whatever you got privately going on affect what you do on that bench.
Trace said she's done some research on the judges, and no, he's not. All right, good job, Trace.
All
on the
right,
case.
Trace on the case as usual.
Whether we're going to need to go into the next week or not. That reminds me, though, I would like the parties to plan on. We're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of.
So we're talking about trial number 2. That's the 2022 case. Brandon Boudreaux. Conspiracy to commit felony 1 murder. Let's listen to that again because he is intending to be the judge for that trial, but he has to be out the door by July 4th. So I'm wondering if Lori feels a certain way about him, if she's like gonna interfere with that and try and extend this trial out to make sure she gets a different judge for the second one. And if he's going to be able to rein her in and keep the first trial on schedule to get to the second trial. But we're also going to see here where she asks him, what is that date that we're going to start jury selection? And he says May 30th. And she scribbles furiously in her notebook, she's going to file. Young black economist, we got $2 on it. We got $2 on it that she's going to file a motion to dismiss for speedy trial not having been met. She already actually has filed one. So technically I already won. I won that $2. But maybe she'll file another one.
Second trial will unfold as far as how many jurors we might need, but I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial.
So they're starting with 200 on trial 1. She had 19, they went through 1,900 jurors in Idaho on her last case. They're starting with 200 here. If they get through, oh, dang it, I may need to start a poll on this. Like, how many jurors do you think they're going to have to go through? Because they're going to do it in batches of 200 jurors. They're going to start with 200, they're going to go to 200 more, then they're going to do 200 more. I'm guessing like probably 600-800 on the first go round, and maybe like 1,200-1,400 on the second go round. Because once you dismiss the ones off the first one, they can't be called back in for the second one. So you're out there like trying to find breadcrumbs. Where can we find jurors that are going to be unbiased in this case? Kresh is in the house. So good to see you in here. We went through some court documents that were dropped on Sunday where the state told Lori where the state told Lori that she wasn't following the rules of evidence. And so we're going to throw out all your stuff. And today in court, Lori's like, well, you don't really need to throw out all my stuff. And the judge is like, well, if you want a speedy trial, we may have to throw out some of your stuff. I just recapped today's hearing in like 30 seconds.
Welcome in, Kresha. Good to see you.
Yeah. I'm going to post her filings on YouTube and on Twitter, X, whatever the hell you want to call it later.
Her comment. Oh my God.
Yeah.
I love you, girl.
They were actually state filings though. Sunday was the state filings, and she filed some more stuff today that I haven't seen on the docket yet. Shit, I was going to go look. All right, let's play the last of this video while I go back to Arizona's docket and see if her stuff is online yet.
And meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th.
So I wonder if he is specifically saying Monday through Friday in June, and he doesn't necessarily plan on going Monday through Friday in April and May for this case, for Charles Vallow's case. That's interesting to me that he specified that. Because, dude, wouldn't you want to go Monday through Friday starting day one? Like, get this all done with as fast as we can? Who knows? Maybe it'll be too taxing on him. He is the judge. He is in control. He can do what he wants.
To try to get as much done as we can. And then there's going to be some dark days there toward the end of June. But we need to get it done by July 4th.
Yana, when are you planning on starting that trial?
So jury selection would be the starting May 30th.
That's where she's furiously scribbling in her notebook, May 30th. Oh, crap, I need to file another motion to dismiss because May 30th is not May 11th. So my speedy trial rights have been violated. I got $2
Trace
on it.
just reminded us that he did say he had some training to go do, right?
He did, yes. In the last hearing, yeah, that we went to a week ago, he says he has some training
So that's
in
why
June.
she's thinking he's the schedule he was just talking about is
Oh,
pertaining.
gotcha.
Yeah.
Gotcha.
Yeah.
So he's specifying around his training schedule. Got it.
Right. Calm down, Joe.
I'm not uncalm.
All right,
I'm
anything else from
teasing
the
you.
state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names.
He's got some nervous tics too. Did you hear him tapping on his desk while he was thinking about responding to the prosecutor's question?
Oh God, I hope you see. I cannot put myself on camera, y'all, because Joe will analyze the shit out of me.
Listen to him tapping on the desk. Listen to this.
All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
Tap, 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 tap.
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in actually.
She keeps looking over her left shoulder at this investigator dude, and like, it's just a weird energy that I feel from that. Like, so I don't think I talked about this at the beginning of this. She specifically asked the judge, I may have mentioned it, but I didn't go into depth. She asked the judge, hey, is it okay if my investigator comes up and sits next to me at the defense table? And he comes up and sits next to her, like right next to her, when off to his left, that's out of screenshot on this camera view, is an actual backup attorney. So why is an investigator at the table next to her when a backup attorney could be seated next to her?
Because the backup attorney is just a backup. This investigator is working hand in hand with Lori. She is the main defense attorney.
Both
The
attorneys are
backup's just-
backup attorneys. Yeah.
Exactly. So
Yeah.
there's the difference.
I just get a weird vibe from it, and it may be nothing. It may be just my imagination, but I just get how many dead husbands does she have? 3 dead husbands now, maybe.
Yeah, but
So I get a weird vibe from it. I get a totally weird vibe from it, and it's just me. Y'all can just blame me for that weird vibe. Oh, all right. Let's play the rest of the video. There is nothing new on the docket. So the stuff that she filed today has not been filed with the clerk of the court just yet. We'll get to it tomorrow if that shows up tomorrow. We'll get to it Thursday if it shows up Thursday.
Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them or on the.
See, he specifically said Gilbert there. So this isn't Chandler. This is Gilbert PD, that 2-hour interview that she's talking about in an interview room is from Gilbert PD. So I was right. What I wrote down on my notes was correct. And you can see the clock on his desk says 8:53. We started at 8:21. So this hearing is barely a half an hour long. So 3 pages of notes isn't bad. I think I did a decent job recapping.
on the other hand, since it was told to you secondhand or showed to you secondhand, whether it's something different than what you thought it was, I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or
Who do you
who?
want me to, I was gonna say, give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that,
I think she makes a mistake here. I think she makes a legal counsel mistake here, because he's willing to issue an order that just says, turn over everything that the prior defense team has. Turn it all over. Everything that you took. So they got the 22 terabyte hard drive. They got that, but they didn't provide any work materials, any like paper files, any of that stuff. And maybe those were copied and scanned, or maybe those were scanned into the 22 terabytes. I don't know. But she's going to say, she's going to narrow it down. And I think this is a defense mistake. No, just give me everything my prior team had. So she made the claim today in the hearing that her prior defense team did not transmit anything over to her new defense team, including herself and her 2 backup attorneys, except for that 22 terabyte hard drive. So she should be asking for everything right now. If I'm my
That
own
might have been
attorney,
all they had was that 22 terabytes.
no, they had to have paper files. They had to
Well,
have
I mean,
paper files.
Well, it's all a
Like,
matter of court record.
No, some
She
of it's
did.
private. Some of it's private conversations between her and them. Some of it is paper. Like it can't all 100%
I
be
get
digital.
you, but her private notes with her old defense team is not relevant here.
But she should still have access to it, and
Evidence
she should be able to make that determination of whether or not it's relevant. That's her decision, not theirs. What she is claiming, and I'm not saying it's true or false, what she is claiming is that they refuse to provide her with anything at all besides that 22 terabytes.
Well,
So
if they're not, I don't know. Maybe there's a law they don't have to, or maybe because I don't know. If
No.
to look into that, I mean,
well, he's getting ready to issue an order, and he's asking her, do you want it to be a broad order that it's everything, or do you want it to be specific? And I think she makes a legal misstep here, and she says, I want it to be specific to something. So let's see what that is.
work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well,
Oh, what's that?
Oh God. Nothing. I'm just laughing at the judge. What he just said.
Oh, right. Yes. No, he's right. So maybe I'm wrong, because he's much more of a legal expert than I am. He says maybe you should narrow it down instead of asking for everything. All right. I see that point.
Mhm.
I dig it. All right.
she knows what the link is and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
Okay. So he actually gave her legal advice. He actually said, I think it would maybe be easier for you to find if we could specify more. So he asked her specifically for her mediator's name on her defense team, how to spell it. He's helping her out. And
Well, he's doing what's. Y'all got to realize he's also doing what's legally. What he has to do legally, right? It's not like
Yes.
he's just helping her out. He can say,
no. You're yes. Yeah, I didn't mean it that
y'all
way.
was
Yeah.
yeah, and I know, but people are, because I think because she's representing herself, we're not separating the two sometimes between the attorney and the client, because she's both, right? And yeah, so by law, this judge is playing fair, in my
He
opinion.
is.
I've watched
He
a
is.
lot of court hearings and a lot of court trials. That's why I say some of the things I do based on other things I've seen.
Yep. Yeah. I like this guy.
Yes, difficult without violating her rights in the process. Exactly. So
Yeah.
nothing can come back and
Right.
bite him in the ass later, right?
We don't need any appeals.
No. So let her have her damn discovery. Isn't it
And
called
do
help
we
or
need an
none?
order, Your Honor, to pick up
Yep.
my husband's phone at Chandler Police so that
My husband's phone, lady. All right.
So
Bonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor,
Right, Britt? Which
obviously the
husband?
state and defense have always
Dead
had
husband?
stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was,
um,
does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
Yep.
That's perfect. Logistically, how's that gonna happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Well, you're certainly not going to get it, Lori.
All right. Be at recess.
All right. So that's it.
And then that's all, folks.
That's all, folks. We've been on here for 3 hours. I think that's enough time for me to invest in this woman.
Joe, 3 hours is normal for a stream once we get going.
Right. It is. It is.
It
true
really
that.
is. Yeah. Yep.
Well,
I might do one later. I got something. I don't know. I got a lot I'm trying to work on at the same time. So I don't know what I'm gonna do later. I'm at home all alone and I'm bored.
I've got an investigation that I'm doing with 857 Tucson about an unsolved case from 2023, Lori Dasso. Or no, Holly Dasso. Damn it, Lori on the brain. Holly Dasso. So I just got the ME report for that in my email like half an hour ago. So we're going to have to dive into that. Holly Dasso.
I'll come hang out for a while, Pokemon, while I'm researching some stuff.
Yeah, let's go. Dang it. Where is... There we go. All right. So if you want to go check out a book club, go check out. Gosh darn it.
What are y'all doing? Reading the books online or on a stream? Or I haven't checked that out yet. I'm confused as to what's going on there.
Well, go check it out and find out.
Are they going to read the book to me? Because I don't want to read it myself.
Right.
Fall asleep reading.
That's right. Okay, everybody. Thank you for hanging out. I appreciate it. Salty, as always. I appreciate having you up here and keeping
Well, thanks
me
for having me.
more or less on track. Everybody have a wonderful evening. Go check out Publicly Buzzed if you got a few minutes, and his book club, Steve's Book Club. And stay tuned for more information on this case. We may have a hearing between now and the jury selection, but if not, we'll be around for the jury selection too.
Yeah. Yep, it's good to see all you guys, and thanks for coming in as usual. Don't forget to hit that like button for Joe.
Have a wonderful evening, everybody.
See you soon, my lovely friends. Have a good afternoon. Don't forget to stop back by and see me real soon. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try.